All right, you're ready to start a business. So what comes first, the LLC or the trademark? Let's dive into it. We'll talk about the difference between the two and how you can secure the name for your business without getting into hot water legally. I'm Scott Radigan. I'm the founder of Functional Lawyer, and let's jump right into it. So LLC or trademark, I get this question quite a bit. First, what is the benefit of trademarking? Should you even do it? Is it necessary? We'll talk about that. I'll talk about which one comes first, as I mentioned a couple of times, what it means to register a trademark, and why you might not want to do it sometimes as well. So LLC, for those that don't know, is a limited liability company. It is one of many types of entities that you could create. It is the most popular these days because it does provide that limited liability, while usually offering pass-through taxation for the business owner as well. I have another video on this channel about S Corp taxation status, which is a totally different topic. We won't get sidetracked there, but LLCs can also be S Corps for tax purposes. But essentially, a company or entity of any type is designed to do two things. One, protect you and your personal assets from the debts or liabilities of the company, meaning if there's a lawsuit and the company is found liable, they couldn't come after your own assets, like your personal vehicle or your personal home or vacation homes, should you have any of those. The other main benefit to different entity types and choosing them wisely is tax classification. So another topic for another video, but most people will start with LLC. It's the most popular these days for generic businesses. In your state, you may have to file a professional corporation or professional LLC. Definitely check with an attorney before you get started if you're building a medical practice. But if you're building just a regular business, whether that's publishing or for online courses or for something else entirely that's non-professional work, you can use an LLC. It's the most popular these days because it is easy, it's flexible. C corporations or corporations have some formalities that you have to adhere to in order to retain that limited liability basis. So for today's purposes, we're assuming that you're starting an LLC. Now, what a lot of people will do is they'll just Google it, or they'll go onto their Secretary of State's website if they know enough to do that, and they will search for names that are possibly available on there. So one question that I get all the time, or this is a part of confusion for new people that are just starting out in business is, all right, I got the domain name, so we're good to go. And so that's a common myth. Buying a domain doesn't protect you, doesn't guarantee you the rights to the name, either the business or otherwise. And even registering the LLC, say it's available in your state division of corporations doesn't restrict you from using it. And so having an LLC doesn't also provide you with the right to use that name. So that's where trademark law comes in. So what is a trademark? It is, well, it's better to give examples. It's either a logo or a slogan or a company name or a product name that is associated with a particular maker, creator, vendor. Famous examples include the Coca-Cola Kirby bottle. Kodak's yellow is actually a trademark, so you can trademark colors, you can trademark the Kirby bottle, the shape. You can even trademark sounds, believe it or not. But most of the time we're looking at business names or their slogans. Like, think of the famous slogans you've heard over the past 30 years, whether it's have it your way at Burger King or I'm loving it at McDonald's or anywhere else that's a little bit more functionally aligned. But those are usually trademarks. You'll know that it has official trademark protection because the little R is present, the little R in the circle, that's all rights reserved. Those people that have a little TM next to their name don't have an actual federally registered mark, but they are claiming rights to use that mark around the country. They're putting other people on notice. Now, that's called common law rights. So what is a trademark? We know what that is now, something that you're claiming. And the purpose of trademark law is to let consumers know who's making it. So if there are a ton of companies out there with red Kirby bottles and they all look like cola, or they'll have variations of Coca and soda kind of in their name, you're not sure which one is from the Coke that's based in Atlanta. It could just be a knockoff. And so part of trademark law is to prevent confusion in the marketplace. That does a couple of things. It helps protect the creator of that content, but it also helps protect the consumers as well. We won't get into all of the details, but know that just using a name in commerce, assuming nobody else has it in your jurisdiction or in your area of service, gives you certain common law rights to it. And that's where you would see that little TM. So this did all come back to the point after all. Now, why would I register a trademark if I get common law rights to it? So registering your trademark federally is guarantees that you are the only one that can use that mark across the country. So just because you looked at your state LLC office or you bought a domain at GoDaddy or somewhere else doesn't mean that you're not infringing on somebody else. So a good thing to do is when you're starting your company or when you're looking to potentially trademark something is to, yes, start with a Google search, but then also start with a search of social media. Looking at GoDaddy is a good idea as well, but those aren't comprehensive enough because trademark law not only protects the actual name, Coca-Cola, but it also prevents people from using similar names, whether that's similar sounding, similar looking, or similarly spelled, or just derivations thereof. So I couldn't start a soda company called Coca-Cola spelled with Ks. It would just be not right, and I'd be infringing on Coca-Cola. Similarly, I could not create a company that was Coca Soda, right? I couldn't say something like that, or Coca Pop with the C's. It would just not be allowed. But we do know that the generic name for soda or cola is allowable. So you are not prohibited from competing with Coke. You just can't try to gain recognition by using their name. All right. So why would you register a trademark? First is to make sure that you're not accidentally infringing on somebody else's mark. So say you had a really cool name idea and you thought nobody else had it, but the US Patent and Trademark Office had a different idea that somebody else is using that either somewhere in the country or somebody has registered that mark at the federal level, and then you would obviously have to switch to a different mark so that you don't get into trouble for infringing on theirs. That can be really expensive if you started your business, you haven't done any trademark search, you are out there and you're getting bigger and bigger and bigger, and then all of a sudden, somebody who has a registered trademark that sounds really close to yours says, hey, buddy, you need to knock it off. It's called cease and desist. You need to cease and desist using our mark. You're infringing on our mark. And you get that, it's pretty scary. So you could challenge it, but if you're getting a cease and desist, it's likely that you're pretty close. So the consequences of that is you have to rebrand entirely. All right. Otherwise, you face legal fees and potentially damages. You have to rebrand entirely from where you've already built up this big following. So it's better to kind of get this locked down now, or at least get an idea of what you can do now. I actually don't offer trademark services, so I have no dog in this fight, but I would recommend talking to a trademark attorney or using a service like LegalZoom or InkFile to kind of help you with a trademark search, because it is not something you can do on your own. And in fact, I don't do it on my own for the trademarks that we own. I pay a trademark attorney as well. So that's where my money is, and that's where my mouth is as well. One of the other benefits is you're protecting your brand if you register your mark. So it's kind of the polar opposite of the first mark, where the first benefit, where you know you're not accidentally infringing on somebody else's mark. If your mark is registered, you'll prevent other people from making similar marks to yours. So it's kind of like you can protect and prevent anyone else from using something that's infringing, likely to cause confusion in the marketplace, where if somebody was looking for your services and they find somebody else and they think it's you, they would have to cease and desist at that point, and you would go through the process for that. And then third, if you end up wanting to pass your business on to somebody else at some point or sell, later on, registered marks do add value to a business from an acquisition standpoint. So it's just an asset that your business owns, and given enough following and brand recognition, can be super valuable. All right, so what should you do first, LLC or trademark? If you have the means, and you should, because trademark with an attorney are about $1,500 total. If an LLC filings are, unless you live in a state like Massachusetts, New York, or California, where the fees are pretty high, LLCs can be registered for under $200. In fact, you could use a company like InkFile, and I'll put a link to them down below. They'll do it for free, and they'll give you, you just have to pay the state fees. So that's a great opportunity there as well. The state fees in that instance vary by state, but again, should be under $200. So which one should you do first? Different attorneys will have different opinions, and this is all for educational and informational purposes, but I recommend doing a brief search on your own, and then seeing if that name is not too similar to any other names. So doing a Google social media search, and then if you've got the means, have a trademark attorney do a trademark search, which is a lot more comprehensive. But if you don't have the means, I would just get the LLC first. Then you could pay the attorney to do a trademark search a month or two from now. And then if you have to switch, it's not so bad. You can also pay it directly from your bank accounts that are tied to the business. So it's actually up to you. Some people would say do them at the same time so that you don't waste your money setting up the LLC with a name that's infringing, and then there's a lot of paperwork after that. So in an ideal world, you would kind of have the trademark search done first, but most people don't do that. So getting your LLC up and running is not a bad idea. To change the LLC name is an amendment fee. It's under $100 most of the time. And if money is tight, starting your LLC and getting going and getting revenue in is usually the faster path. The LLC registrations, again, about $150. Trademarks about $1,500 if you go through an attorney. So LLC is cheaper and it can get some revenue coming in. And then already, if you start to use the mark in commerce, so making sales, then you have some common law rights to the mark already. And then you can prove that when you go to apply. So that was a long one, but LLC versus trademark, which comes first, with a lot of trademark history and rights thrown in. Check out our other videos on S Corps and elsewhere on our channel, and we'll see you guys next video.